Hi guys, my name is Teh Tai Yong. This is another series of the video sharing about the various concepts of law. Today I'm going to share something called the Doctrine of Frustration. Now, to recap the discussion about the force majeure, it is an unexpected or extraordinary event that happened after both parties enter into the contractual relationship and they find out that they can't perform their obligations. So this is so apparent during the MCO, the Movement Control Order period, where the parties are unable to, for example, to operate businesses, and they are not able to go out from home because everybody is staying at home, and therefore a lot of contractual relationships, a lot of contractual obligations cannot be performed during the MCO. Now the legal question is whether are the parties liable during this period. So the last video session I shared about the concept of force majeure, basically to say that if during the negotiation of the parties before they enter into the contract, they've inserted the force majeure clause in the agreement to say that in the event such unexpected things were to happen, then what will happen? Either the obligations of the parties will be suspended. Now, if such a clause is not stated in the contracts, then the party cannot rely on the force majeure contract. Then what will happen? So one of the alternatives in Malaysia is to rely on the doctrine of frustration. Now this frustration is different from the concept of frustration that today I just feel frustrated because something happened. So this frustration is frustration that you are unable to perform contractual obligation. This is actually provided under Section 57 sub 2 of the Malaysian Contracts Act. So which reads, a contract to do an act which after the contract is made becomes impossible, or by reason of some extent which the promisor could not prevent, unlawful, becomes void when the act becomes impossible or unlawful. So this is the meaning of what is frustration all about. Come to our second question. What are the categories of the frustrations? So there are, over the years, the courts have actually come up with several examples of the categories of frustration. Number one, frustration of the subject matter. This brings us back in 1863, where there's English case law called Taylor and Caldwell, where the parties actually rented a music hall for a performance of a music concert. And what happened was the concert hall was burned down. So the subject matter was burned down and it was destroyed totally by fire. Now in that situation, it is impossible for the parties to perform the contract because the subject matter is no longer there. Another example is illegality, where the parties sign the contract and after that the law changed to make the contract itself to be illegal. Now this could happen during the wartime where the parties signed a contract to supply certain goods to the other party. But what happened after the contract was signed? There was a war, and the country actually imposed the law to actually prohibit trading with the enemy of the state of another country. So therefore, perform the contract became illegal, so the party could not actually perform the contract. The third example is that the non-occurrence of the event, which was fundamental to the agreement. Another English case is that someone actually rented home to watch the coronation procession of the king. So what happened at the time was the ceremony was cancelled because the king wasn't feeling too well. So the purpose of him renting the room is to watch the event, but the event itself was cancelled. So therefore, the performance of contract it became impossible. The last example is death or incapacity of the contract for the rendering service. If someone enters in a contract with you and to provide certain services and the person actually died, it is impossible for the person actually to perform the contract. Therefore, by virtue of doctrine of frustration, then the contract would not be able to be performed. Now the third question is, what are the bars to frustration? That means, what are situations that you cannot rely on frustration? Number one is self-induced frustration. That means you have a part to play into this situation. So that is to say that you should not be contributing to the event. It has to be external force, external event that actually prevent you from performing the obligation under this contract. Right. The next thing is inflation or the increased cost of contract should be a bar to rely on the frustration. That means after you sign, then you find out the prices actually fluctuates and it becomes more expensive for you to perform your side of the obligation, and therefore you're trying to argue frustration to come out with this contract, and this is actually not allowed because the law does not provide you in such a situation. Question number 4: what are the effects if you argue based on the doctrine of frustration? The answer is the contract will be terminated. The contract will be terminated and you'll get out from the contract. Now, at this juncture, you ask me the 5th question: what are the differences between the force majeure clause and the doctrine of frustration? To rely on the force majeure clause, it has to be expressly stated in the contract, whereas if the contract does not have any express provision, then you have to rely on the doctrine of frustration. The difference number 2 is the level of threshold for frustration is higher compared to force majeure. Force majeure, you state exactly, for example, war, riot, fire, and you rely on exact provisions that you have actually agreed upon. When there is no express provision and you rely on the doctrine of frustration, then the level of impossibility to perform the contract is much higher. Lastly, what the difference is the remedies or the outcome of you relying on this. Now, if you have a force majeure clause, it all really depends on what's agreed upon. For example, a tenancy agreement, if it says that in the event there's a government administrative order to shut all the businesses, then your rent obligation shall suspend. So you follow exactly what's stated in force majeure clause. Whereas if you rely on the doctrine of frustration, the only situation is that the agreement will be terminated. All in all, during this MCO period, you have to see whether your contract, the applications you enter into, does it satisfy the test of this doctrine of frustration to be able to rely on. Alright, so I hope this short video is helpful for you. I hope everybody stay healthy and stay at home during the MCO period. Thank you.